Good evening. Welcome to 42 Bedford Row. This is another in the series of the talks that our housing team is doing. Tonight we're going to talk about the Homes Fitness for Human Habitation Act of 2018. And you're going to be hearing from Katherine Archer first, and then myself, Desmond Kilcoyne. Katherine's going to go through in detail the structure of the Act and what essentially you need to know in practice. And then I'm going to, in the second half of the talk, I'm going to look at one or two more selective areas. Hopefully we have the technology to transfer between our various seats in very different places while we're doing this. And I will hand over now.
Thank you, Desmond. I will now share my screen. And we will start off with just a brief overview of how the Act was introduced. So prior to the introduction of the 2018 Act, there was in fact already an implied covenant in leases by virtue of Section 8 of the Landlord and Tenant Act 1985, that homes would be fit for human habitation when let and kept in that condition throughout the tenancy. That obligation originated in the Housing of the Working Classes Act in the 1880s, and that was in respect of tenancies at low or modest rent, and it went through various iterations before it settled for some time in sections 8 to 10 of the Landlord and Tenant Act 1985. However, over time, those sections became almost entirely redundant, as the implied obligation applied only to tenancies where the rent payable was yearly £80 in London and £52 elsewhere in the country, and that figure hadn't changed since the 1950s. And so for the obvious reason that barely any properties continued to be leased at such a low rent, the obligation became essentially dead letter law. So having been first introduced by Karen Buck MP as a bill in 2015, the new Act ultimately completed its passage through Parliament in December 2018, and it came into force on the 20th of March 2019 in respect of new tenancies, and then into full force in respect of existing tenancies too on the 20th of March of last year, but I'll go into a little bit more detail about that in a minute. The new Act operates essentially by introducing new sections 9A, B and C into the Landlord and Tenant Act 1985, as well as amending other sections. And in broad summary, the new sections imply a covenant of fitness for human habitation into most tenancies of dwellings in England, which is of course in addition to the main repairing obligation under Section 11 of the 1985 Act. So turning now to look at which tenancies the new implied terms apply to, this is contained in Section 9B of the Landlord and Tenant Act, and as alluded to, the application of the Act came in two stages to give existing tenancies a 12-month window before it also applied to them. And so from the 20th of March 2019, it's applied to all new tenancies, including replacement tenancies of a term of less than 7 years, including new periodic tenancies granted on or after the 20th of March 2019. And so that's really any tenancy that's newly granted, renewed, or comes into existence as a periodic tenancy after the end of a fixed term. It also applies to all tenancies that began as a fixed term prior to the 20th of March 2019, but became periodic after the 20th of March 2019. So statutory periodic tenancies after an AST fixed term, or an assured tenancy after a starter tenancy, or a secure tenancy after an introductory tenancy. Then from the 20th of March of last year, 2020, it has since then applied to all periodic or secured tenancies that were already in existence on the 20th of March 2019 as well. And accordingly, the result is that really it's only non-secure fixed term tenancies that are granted, that were granted before the 20th of March 2019, which aren't renewed, that avoid the Act up to their expiry. For clarity, it doesn't apply to licenses to occupy dwellings. So for the Act to apply, the lease naturally has to be one for a dwelling where the dwelling is let wholly or mainly for human habitation, and that's set out in section 9b, subsection 1. Interestingly though, for these purposes, section 9b(7) tells us that it's immaterial whether the occupation for human habitation needs to result from the lease itself or from a lease derived out of it. And that's something that Desmond will consider when looking at the intermediate landlords and the differences between the new Act and section 11 cases a little later on. Moving on then to the crucial question of what the implied covenant introduced by the new Act actually is. That's found in section 9A of the Act, of the 1985 Act. And it is that the dwelling is fit for human habitation at the time the lease is granted or otherwise created, and that it will remain fit for human habitation during the term of the lease. And section 9A subsection 4 means that contracting out of that obligation is not possible for landlords. So the next obvious question is, what does fit for human habitation actually mean? And for this, we look to section 10 of the Landlord and Tenant Act. And that provides that when determining whether a house or dwelling is unfit for human habitation, regard shall be had to a list of matters, including repair, stability, freedom from damp, internal arrangement, and importantly, any prescribed hazard, which I'll come on to in a minute. The full list of matters is set out on the slide there, and is of course in section 10 as well. The section goes on to say that the house will be regarded as unfit for human habitation if and only if it is so far defective in one or more of the matters listed that it's not reasonably suitable for occupation in that condition. Now, this definition in section 10 remains largely unchanged from its previous iteration, and the main change is really the introduction of the prescribed hazard in the list of factors to which regard must be had. So those prescribed hazards that are referred to in the amended section 10 are the same hazards listed in Schedule 1 of the Housing, Health and Safety Rating System 2005 regulations. There are 29, and I won't go through the whole list, but examples are mold growth, excess cold, noise, etc. And the list importantly includes both Category 1 and Category 2 hazards. The definition of hazard for the purposes of section 10 is as per section 2, subsection 1 of the Housing Act 2004, and so means any risk of harm to the health or safety of an actual occupier of a dwelling or house in multiple occupation, which arises from a deficiency in the dwelling or HMO, or in any building or land in the vicinity, and that's whether the deficiency arises as a result of the construction of any building and absence of maintenance or repair or otherwise. Looking then briefly at the reach of the implied term, we know from section 9A landlord has an interest in, and this is something that Desmond will look at in a little more detail later on, and so I won't say any more about that now. In terms of what is actually required of landlords, sections 9A, subsections 2 to 3 of the 85 Act tell us that exactly what a landlord is not responsible for. So it's clear that what does not fall under the obligation is unfitness, which has been caused by the tenant failing to behave in a tenant-like manner, and for works or repairs for which the tenant is liable, rebuilding and reinstating the dwelling in the case of destruction by damage or by fire, storm, flood, or other inevitable accident, keeping in repair or maintaining anything which the lessee is entitled to remove from the dwelling, carrying out works which or repairs which, if carried out, would put the lessor in breach of any obligation imposed by any enactment, and finally carrying out works or repairs which require the consent of someone else, which has not been obtained. So those are matters for which the landlord is not responsible. And looking at section 9A, subsection 3 specifically, that sets out that the obligation will also not make the lessor responsible for unfitness attributable to the lessee's own breach of covenant or disrepair which the lessor is not obliged to make good because of an exclusion or modification under section 12 of the 85 Act. And again, this is something that Desmond will look at in a little more detail shortly. Moving on to the important question of breach, what must be remembered is that not every defect connected to the list of matters set out in section 10 will render a dwelling unfit for human habitation, and it will be unfit if and only if it's so far defective in one or more of those matters that it's not reasonably suitable for occupation in that condition. And whether that is the case or not is a question of fact for the court. And without there having been any notable decisions made under the new Act to date that Desmond or I have located, guidance is gleaned from cases exploring fitness for human habitation under previous legislation. So, for example, in Wise and the Secretary of State for the Environment, Ms. Justice Forbes made clear that the correct approach was not to consider potential defects in isolation, but to look at the totality of the defects and ask whether that is sufficient to render the dwelling reasonably unsuitable for occupation. I've also included there a note that the key question is of course whether the property is suitable for occupation or not, and it's not necessary to prove a prescribed hazard or have a housing health and safety rating system assessment in order to establish unfitness. Expert evidence on that issue is likely to be admissible and may be desirable in more complicated cases, but certainly is going to be unnecessary in simpler cases. So, for example, if there were no plumbed sanitary conveniences in the property, an expert opinion would not be necessary, as the property would evidently be unfit. So, looking at a few examples where homes have been found to be unfit under previous legislation. In Somers and Salford, the House of Lords considered a case where attempts to open the only window in one of the two bedrooms in a property could only be made with risk of serious bodily injury to the person making that attempt. And it was held that the jamming of a bedroom window so that it couldn't be opened without danger impaired the ventilation of the room, and in the size of the house in that case, this meant that the property was not suitable for human habitation. In Todd and Clapperton, which is a Scottish case that was decided in the Court of Session, it was considered that a pane of glass in a door which didn't conform to British safety standards and was likely to break when pushed or leaned on and so cause injury, that rendered the property unfit for human habitation as well. And finally, in Horrocks and Pidwell, Judge Shepherd determined that a defective lavatory, as well as serious dampness due to defects in the roof and guttering, also rendered a home unfit for human habitation. Turning to some examples where the courts have not found properties to be unfit under the previous legislation. In the case of Daly and Elstree, DC, the Court of Appeal found that the mere fact that a house fell below the general standard of other houses in its locality did not render it unfit for human habitation. And here the hot water system in the house was out of order, but the tenant had running water and a stove to heat it on, and so the court found that the house was not unfit, which seems to require pretty serious defects before unfitness can be found. In Stanton and Southwark, which is also there on the slide, it was held that rats occasionally coming into a property from a nearby sewer was not the same as them actually forming part of the premises, and the dwelling was accordingly, in that case, not unfit for human habitation. It's also noted that in Buswell and Goodwin, the Court of Appeal made it very clear that the obligation to keep premises fit for human habitation didn't apply to premises which couldn't be made so fit at reasonable expense. So in that case, again, under previous legislation, the landlord was seeking a closing order as a result of the poor condition of the property, and the court made very clear that the landlord was not in breach of the fitness for human habitation obligation, as the property could not be rendered fit at a reasonable cost to the landlord. What exactly that reasonable cost will be under the new provisions is to be seen. Until further cases emerge that are decided under the new provisions, guidance in respect of breach can also be gleaned from Section 1 of the Defective Premises Act 1972, which imposes a duty to carry out works on dwellings properly, so that following the works, the dwelling is fit for habitation. Now, unlike the new obligation that we are discussing, this isn't a continuing duty to keep the dwelling fit, and the test is not worded in terms of human habitation, and so the obligations aren't identical, but nonetheless there is expected to be some overlap in the court's interpretations of the two terms, and case law decided under this section might therefore be useful. So the standard for fitness adopted in connection with that section of the 1972 Act is clear from the Rendlesham Estates case, and the question is whether the property is capable of occupation for a reasonable time without risk to the health or safety of the occupants, and without undue inconvenience or discomfort to the occupants. And Mr. Justice Edward Stewart also set out in that case various relatively helpful factors that are pertinent to the meaning of fitness for habitation, and some of those are included on the slide. So again, it's confirmed that it is a matter of fact in each case, that it relates to defects rendering the dwelling unsuitable for its purpose, and dangerous defects that render the dwelling dangerous or unsuitable, and its purpose is certainly not to address minor defects. It also sets out that defects in one part of the dwelling may render the dwelling unfit for habitation as a dwelling house, even if that defect doesn't apply to other parts of the dwelling. And again, it makes clear that we must consider the effect of defects as a whole rather than in isolation. It is also worth noting, and it's not included on the slide, but that the government has published some non-statutory guidance for tenants and landlords in relation to the kind of problems which might render a property unfit under the new provisions, and that can be found on the gov.uk website, and really just provides a basic overview of the new provisions. finishing off with breach and the requirement of notice, there are no express provisions in the Act on notice needing to be given to the landlord, but neither are there in Section 11, which is the existing disrepair provision, and it can confidently be assumed that the same common law notice requirements will apply as with Section 11 and indeed with the former Section 8 obligation as it was before the 2018 Act. So that is, for any unfitness within the dwelling, the landlord's liability to the tenant will not start until the landlord has had notice of the unfitness, and the landlord then has a reasonable period to rectify the unfitness. And for any unfitness that arises from the landlord's retained parts, so common parts or the exterior of a building, the landlord will be deemed to be on notice as soon as the unfitness arises, but then will be liable after a reasonable time to remedy the defects. And finally, for completeness, Section 9A, subsection 7 to 8 of the 1985 Act also imply a new covenant by the tenant that the landlord or a person authorised by the landlord may enter the dwelling for the purpose of viewing its condition and the state of repair at reasonable hours of the day and on 24 hours written notice. Now, that's been a fairly quick whiz through the most important provisions, but I will now pass over to Desmond for him to look at some of the more specific issues in a little bit more detail.
Hello. Thank you very much, Katherine, for that. This is the second section of the talk where I'm going to, as Katherine's just said, I'm going to discuss things, one or two little areas in a little bit more detail. You'll have seen on the handout for the talk that I'm going to start this section by comparing Section 9A and the new obligation with the obligation in Section 11. I think that's a useful way of doing it. It shouldn't be forgotten, of course, that they're sitting side by side in precisely the same Act. And we'll see that some of the wording of the provisions which relates to the fitness obligation are precisely the same, precisely the same wording as applies to the Section 11 obligation. And again, one would expect them to be applied in precisely the same way. What's perhaps also interesting is the fact that sometimes there's some wording, as we'll see, there's some wording in relation to the Section 11 obligation, which is not there in relation to the Section 9A obligation. And then the question then is, what is one to take from that, and what is the meaning intended by Parliament? So I'll start with one of, I think it's 4 sections comparing Section 9A with Section 11. I'll start with the principle of contracting out. Just to mention, to start with, you'll see there, Section 11, 2A, B and C, that's obviously in relation to Section 11. Those not so much contracting out, but quite closely related. Those provisions specifically confine the Section 11 obligation so that it does not cover works which a tenant is required to do, or the rebuilding of the property if, say, there's a fire, or for example, the repair of the tenant's fixtures that the tenant's able to remove. Precisely the same wording applies in a provision in Section 9A2, A, B, and C in relation to the fitness obligation. Moving on, after Section 11, as regards the Section 11 obligation, Section 12, the next section in the Act, states very clearly that there is to be no contracting out. You cannot, either in the lease itself or in a side agreement, cannot contract out of the obligation of in the Act. That the landlord is always bound to owe that obligation to the tenant, and that is precisely the same for Section 9A. But there are one or two differences, and these are interesting. And the first point to make is that, in fact, Section 11, although there is this general principle that there is to be no contracting out, can be contracted out by making an application to the county court with the consent of both parties, and the court can authorize an agreement where a landlord is not obliged to fulfill the Section 11 obligations. Now, that is almost unheard of. Certainly, I have never come across it. There's no significant case law on it, and practitioners I would imagine that most practitioners have not come across this in their practicing life. However, it is an interesting section. What is, to start with, notable is that there is no provision for a county court agreeing to the contracting out of a Section 9A obligation. That's perhaps unsurprising, but that simply cannot be contracted out of in the same way. However, so going to the next slide, Section 9A nevertheless contemplates that a landlord may have agreed with a tenant to contract out of Section 11, and if that has been sanctioned by the county court, then in those circumstances there will be no liability under Section 9A as regards fitness, which is wholly or mainly attributable to any disrepair which would have fallen under Section 11 but for the exclusion. So essentially, there is therefore, this actually does afford a way of getting out of the Section 9A fitness obligation. You apply to the county court to exclude Section 11, and there may be a knock-on effect which absolves the landlord of liability for lack of fitness if in fact it is covered by the ambit of the exclusion. So that you might say, well, why are we talking about this, given that I've said that landlords' applications to the county court under Section 11, under Section 12 to exclude the obligation are unheard of. Well, I'm going to come back to that because I think there is a potential point that should be looked at where it may just be conceivable that such applications might now be made. Moving on, there is another provision, I think, which is an interesting provision connected with contracting out. Section 9A(3) little a does not impose on the lessor any liability in respect of the dwelling being unfit for human habitation if the unfitness is wholly or mainly attributable to the lessee's own breach of covenant. Now, this is a new provision. There's no equivalent for Section 11. So what is being contemplated here by the draftsman? Not entirely clear. The effect is, if you put into a contract for the tenancy, if you put into the contract that the tenant has to do certain things, if the tenant does not do those things, and then unfitness arises out of the failure of the tenant to do those matters, well, then the landlord can't be held responsible. And it seems to me that that therefore gives rise to some drafting implications. And several questions really arise here. I think the first question is, to what extent can obligations be imposed on the tenant legitimately so as to avoid or minimize the liability under the Act? That's the first question. And indeed, whether such obligations imposed on the tenant amount to, in effect, an unlawful contracting out. Quite obviously, if there are obligations about fitness in relation to let's say the gas boiler, the landlord must ensure that the gas boiler doesn't leak, it doesn't cause any form of hazard for the tenant. That's contemplated by the Section 9A obligation. It's also covered under Section 11, that the boiler be in proper working order. But could the landlord frame some sort of obligation on the tenant to sort of to effectively erode the position and to get the landlord into a situation where if the tenant fails to comply with maintenance of the gas boiler or otherwise, that in fact the landlord escapes the ambit of the obligation? That's the first question there. And if indeed the landlord can to any extent minimize the liability by doing so, when, in circumstances that come up in practice, when might a landlord appropriately do so? Lastly, I just say on this point, lastly, it would therefore be relevant to to landlords who are contemplating entering into new tenancies. It's relevant now, today, in the light of this new obligation that's implied. It's relevant for landlords to look at whether there are ways in which they may minimize their obligations by increasing the burden on tenants in the way that they relate to and behave in relation to the conditions in their flat. It's also relevant even if you're dealing with an existing tenancy where the fitness obligation has already been imposed, because of course in certain situations landlords can still today vary the tenancy terms. For example, social landlords or local authority landlords who may be able to operate variations of the terms under Section 102 and Section 103 of the Housing Act of 1985. So they may wish to consider whether they want to impose further obligations on tenants in certain key respects. So those two matters are both matters, in fact, that I'll come back to during the course of discussing these areas of interest. And in fact, we'll come to it quite shortly, because I'd like to discuss now what might be contemplated as being breaches of Section 9A, which what sort of situations might be breach of Section 9A, which were not historically breaches of Section 11. As we know, Section 11 is a repair obligation. It focuses on the physical integrity of the building, and a disrepair obligation is triggered once there is physical deterioration or physical disrepair in relation to the structure of the building. It is also triggered if an installation for providing water, gas, or sanitation is not in proper working order. And the first, and I think this is probably the most important type of situation, which now will be a breach of Section 9A, which would not have been a breach of Section 11. The first situation is when, as we see here, there is condensation, dampness, and mold. That really was not caught by Section 11. As in general terms, if there is no physical deterioration or everything is working otherwise correctly, there will be no obligation. Only exceptionally in a situation such as in Quick and Taff Ely, where the condensation was giving rise to physical disrepair, and the only sensible way of carrying out a repair was to repair a defect which effectively would stop the condensation. In that exceptional situation, that was about the only type of situation that might be caught. Well, today we don't need to go into the niceties that the courts went and the hoops that they jumped through in order to reach that result. Today, if it is not reasonably suitable for occupation, a flat which suffers from condensation, dampness, and mold will be in breach of the Section 9A obligation. And this is obviously important. This ground is covered to some extent today by the Environmental Protection Act. If a flat is prejudicial to health, then of course you can go down to the magistrate's court and you can get an order in relation to condensation, dampness, and mold. And this will also now be covered under the civil obligation in relation to fitness for human habitation. So, question I think that arises here is are there any limits on this at all? This is probably one of the most significant new areas which opens up to civil liability. And I think there are some interesting issues that arise. There are some interesting issues that and potential limits to the liability. I'm going to set out three relevant subsections at the bottom there. I'm going to start with Section 9A, subsection 6. Of course, it's worth emphasising, as Katherine has said, that the obligation does not apply in relation to any part of the building in which a landlord has no interest. Now, if therefore the work that is needed to be done is in an area of the building, for example, walls, imagine there's a cold north-facing wall that in fact is not, strictly speaking, within the demise of the landlord, well then in that situation there can be no liability in relation to fitness. And a similar point can be made even if the landlord has a demise of the area of the building on which the work needs to be done, but even though the landlord has the demise, the landlord has no right to carry out the works. For example, if there is a superior landlord and there is an obligation by the landlord not to carry out any additions or alterations to the building, again, that may be a limitation, a limitation upon the circumstances in which the obligation can be enforced on the landlord. And lastly, there is section 9A3A, which is the section I was just talking about, which is that there can be no liability for unfitness where the unfitness arises wholly or it's wholly or mainly attributable to the breach of a tenant covenant. And now that is very interesting, because in the context of condensation, dampness and mold, as will be appreciated if you have been down to the magistrates court and done these types of cases, and it's also relevant where these issues are also relevant where if you can establish under section 11 a liability in relation to condensation, dampness and mold, which will it is of course possible where there is some physical disrepair, for example, some rising dampness or some penetrating dampness, which triggers the section 11 liability. If that occurs and section 11 is in play, then of course these same similar issues arise. And those are, well, to what extent is the tenant at fault for the condensation, dampness and mold? And we, no doubt you'll be very familiar with the issues that are commonly raised. And the question that I'm inviting you to consider is whether these sorts of issues can be legitimately put into the contract and framed as obligations. These particular matters, which I'll come to in a second, can you put into the tenancy agreement that the tenant has obligations in relation to these things in order to escape liability? So, for example, an obligation always to use the extractor fan in the kitchen and the bathroom when using those rooms. An obligation always to keep lids on the pots in the kitchen when you're cooking. What about an obligation not to dry washing in the flat? You could put that. I can't see why that would not be a legitimate obligation to introduce into a tenancy agreement. An obligation that the tenant, what about this? An obligation that the tenant must keep the property heated with background heating of a certain level at all times. Could you introduce that as an obligation? And lastly, if mold appears on the surface of any window or wall or ceiling, an obligation on the tenant to immediately to treat it and wipe it off with bleach, and an ongoing obligation then to prevent its recurrence by further regular cleaning. Imagine a situation where a tenancy contains conditions, all of those conditions all set out. Condensation, dampness, and or mold is occurring in the property. Could you then argue if in fact mold has, let's say mold is now occurring on some part of the, in some part of the flat, could you then argue that this is either wholly or indeed mainly attributable to the tenant's breach? And if that's right, of course, liability will be escaped. So 2 points to make there. Obviously, in any given situation, it's always going to be a matter for expert opinion as to what is the main cause of the particular dampness and or mold. It may well be that even if you have all of those terms written into the contract, may well be the case that the expert who is ultimately persuasive before the court is able to establish or able to persuade the court that the lack of insulation in the north-facing wall is the dominant reason. So irrespective of the terms and the way that the tenant's using the property, it really doesn't matter. I might also included that the tenant you could have a term in there saying the tenant is only allowed to have a certain number of people occupying the property. Another reason why you often get dampness or occasionally get dampness is due to overcrowding, an excessive number of people using a property. All of those terms, nevertheless, in any given case and subject to what your experts are going to prepare to say in it, all of those terms may assist actually into something quite substantially in avoiding or mitigating the position, or a landlord's position in relation to that particular form of unfitness for habitation. On the flip side of the coin, if you are a tenant and if you're a tenant's advisor, you would obviously want to read the tenancy agreement very carefully to see if these sorts of terms are being introduced by landlords from now on. So that's one type of breach. No doubt, there are quite a number of different types of new hazard, and Catherine's referred to the list of hazards that's set out in the Act, and also the list of hazards that's referred to by reference. There are quite a number of different types of situation which could give rise to a health hazard, which may fall under the obligation and not previously under Section 11. But I've just picked out one or two more, and one is fire safety. Fire safety is really not covered as far as apart from keeping the electrical installations and the central heating boiler in proper working order in circumstances where there might be a fire caused by a defective installation. Apart from that, the general principles of fire safety are simply not caught by Section 11. Section 9A does catch those. I'm sorry, it says Section 9A 91. That's a 9 instead of another bracket on the bullet point there. It does cover fire safety, and so that could conceivably cover installations within the dwelling, as well as the fabric of the dwelling or between one dwelling and another. It could cover the common parts if there is an absence, for example, of fire doors. And clearly it could cover external cladding on a building. There's no reason why it couldn't cover the sort of situation that gave rise to the disaster that occurred on Grenfell Tower. As will be the case in relation to all potential hazards that give rise to potential civil liability under this new section, there is going to be a threshold, and that will always be a matter for expert opinion. There will be evidence will be needed to assess what sort of risks any particular problem give rise to, although ultimately it will be a matter for the court in any given case to decide whether in fact the relevant test has been satisfied. The test being not reasonably suitable for occupation. And of course, when we consider whether an expert is prepared to say that there is a serious risk or a medium risk in relation to fire safety in any given building, in relation to any given dwelling, there may also be measures that can be taken to mitigate the risk, potentially inexpensive measures that might be taken to mitigate the risk. And there may be a balance, therefore, between trying to find, maybe in any given particular situation, between identifying precise risk and also identifying whether, in fact, risk that takes a particular problem over the threshold of into unfitness, as to whether it nevertheless can be brought back by reasonably limited measures to increase the level of safety for the tenant to an acceptable level. So fire safety is obviously, in addition to mold and dampness, another one. A third one down worth considering is excess cold. I think this raises some interesting questions. Central heating obviously would be covered by Section 11 under the principle of whether it was in proper working order or not. But we're here in Section 9A thinking about something slightly different, which is inadequate heating systems that don't really perform provide adequate heat for the tenant, or indeed non-existent heating systems, because there is no strict requirement that there be heating within properties, although that's very rare today. And I think the question that's going to be raised here, and I don't purport to answer it in this run-through of topics and principles, I think an interesting question is going to be whether the system must be affordable for the tenant. Obviously, that gives rise to another threshold issue. there's going to be the first question for the expert as to whether the heating is the level of heating generated is so low that it gives rise to some sort of risk of health or is excessively cold. And then there may secondly also be an issue about the affordability for the tenant and whether and what indeed is affordable in any given situation. You'll see there on the bottom, I've just mentioned one further one that I think is an interesting news situation that may be covered by Section 9A, and that relates to noise. And by noise, I'm referring to the condition of premises whereby a tenant is able to hear the ordinary domestic noise being generated by a neighbouring dwelling. Practitioners will be familiar with the House of Lords case in Southwark and Mills, very famous case, which created the general rule that if there is poor sound insulation, which is giving rise in effect to significant disturbance, a landlord generally is under no obligation to remedy the situation and improve the sound insulation. That is the general position at law at the moment. If your building is extremely noisy, in short, you have to put up with it and ensure you don't fall into deteriorating relations with your neighbours, so that the level of noise generated becomes a means of argumentation between the parties. It's a difficult situation, and 10, 15 years ago, there were a lot of cases about noise insulation. You don't hear very many today. You don't come across them. An attempt was made to deal with this under the Environmental Protection Act. Is it possible that excessive levels of noise are prejudicial to a person's health? And of course, in principle, they might be. It is possible that the background noise generated by a neighbouring property would be simply so bad that it's unacceptable. However, under the Environmental Protection Act, in the case of Vella and Lambeth, the Court of Appeal took the view that that wasn't the sort of concern that the original acts that eventually gave rise to the Environmental Protection Act of 1990. That wasn't the sort of concern that they were focused on, and accordingly, poor sound insulation for the purposes of the 1990 Act is not something that can be prejudicial to health for the purposes of the scheme. Well, today, I don't think there's any such necessary limitation on the ambit of Section 9A. So it's very much a question, and it will be interesting to watch this space as to whether anything takes off in relation to poorly insulated premises. So a third area, which I think is interesting, is the question of intermediate landlords. I'm going to run through this point quite quickly, but this is not a problem that is obvious as a problem between landlord and tenant, and the precise ambit of an obligation where the tenant is living in questionable conditions. This is more a structural problem, and it relates to the background fact that in English land law, there are freeholds as well as leaseholds, and a number of leasehold interests may be created in the chain before the final leasehold, sublease, is created where the tenant or the occupier concerned is living in the property. And the significance of it is as follows. I should say that there is nothing like this in Section 11 for reasons I'll explain in a minute. But Section 9b, subsection 7 is the relevant section, and it says that it is immaterial whether the dwelling is to be occupied under the lease or under an inferior lease derived out of it, i.e. subtenancy. So the obligation is imposed whether it's a lease of a dwelling, whether it is intended that the dwelling will be occupied by the immediate tenant, or what we can also call the intermediate landlord, or a subtenant to whom the intermediate landlord is going to lease the property. It's also immaterial that the lease also demises other property which may consist of or include one or more other dwellings. So the Section 9A unfitness obligation applies where it is the lease of 2 or more dwellings. Well, that's quite an interesting structural obligation as regards the chain of leases that you may have. In a simple case, there is no problem. That is, you have a landlord and a tenant. Landlord freeholder and a tenant has a lease. Section 11 binds both the landlord, and it's for the benefit of the tenant, and Section 9A binds the landlord for the benefit of the tenant. But what about a lease of a building with a number of habitable units? Here, the landlord is the head landlord of the building, the freeholder. T takes a lease of the whole building, so we're going to call him the intermediate landlord. And T then lets out the individual flats to a series of subtenants, S1, S2, and S3. So we have a chain, L, T, and S. My question is, where do Section 11 and Section 9A apply in this chain? And there isn't, to start with, an easy first answer. Between the tenant and each subtenant, T and S1, T and S2, as in the simple case, both Section 11 and Section 9A1 apply. That's not a problem. But does Section 11 and does Section 9A apply between L and T higher up the chain? Now, Section 11 is phrased very similar terms to Section 9A. It says it applies to a lease of, and I emphasize, a dwelling house. And that is defined further in Section 16 as meaning a lease by which a building or part of a building is let wholly or mainly as, I emphasize, a private residence. And the use of the indefinite article in a dwelling house and a private residence is generally taken to mean that Section 11 would not apply between L and T. Section 11 will only apply where the subject matter of the lease is a single dwelling. That is the general view. It's not entirely settled, but that is the general view. Well, consider now the question of Section 9A1. Does that apply between a landlord and a tenant? The L and T. Well, in fact, as I've said, Section 9A1 has very similar wording. It applies to a lease under which a dwelling is let wholly or mainly for human habitation. But if I go back a few, and I'll try to do this smoothly, if I go back a few slides, in fact, Section 9B7 says it's immaterial whether the dwelling is to be occupied under the lease or an inferior lease, and it's immaterial whether the lease also demises one or more other dwellings. So that really raises a very interesting question. Is it the case that Section 9A would apply between L and T? And I think the answer to that may well be yes. What sort of examples am I thinking about in practice? Certainly one example is where local authority temporary accommodation is provided for homeless applicants. Local authorities commonly take a lease. They also take licenses, but it's possible that they can also take a lease. They take a lease, a short-term lease, and then they sublet or sublicense those premises out to the homeless applicants. And obviously there is a whole issue about whether those arrangements are leases and licenses, but this also can occur in other sectors as well. There is a question, if leases have been created, whether Section 9A applies. You can say that to start with, if you're concerned about this and you're dealing with a series of transactions where you're dealing with a head landlord and intermediate landlord, the first obvious way then to avoid this happening is therefore to make sure that your head lease is more than 7 years. That would be one way of doing it. But if it's less than 7 years, then in principle, I see no reason why Section 9A will not apply. And that means that if T, the intermediate landlord, gets into trouble with the subtenant, S, and there is an issue about unfitness, if the subtenant sues the tenant, if this is correct, and I think it is, there will then be an indemnity owed by L to T, the intermediate landlord, in relation to the lack of fitness. L, the landlord, cannot contract out of that unless the landlord has obtained a Section 11 exclusion. And that's one possible way in which the landlord, L, our head landlord, might want to contract out of it. And I suppose another one might be where L and T arrange that the intermediate landlord has obligations which the intermediate landlord has to comply with in order to avoid L being exposed to the fitness obligation. So you need to consider, I think today, that is an issue. If you're dealing with these sorts of structural issues, that is an issue that needs to be considered as to what might be implied into the agreement between a head landlord and intermediate landlord. It also needs to be considered in any negotiations, and you need to be aware of that. If the agreement between L and T does indeed have a positive obligation, and that's slipped in there, and you have a situation where it wasn't considered, and you're actually having to deal with that, I just raise a final thought. Can the subtenant sue the head landlord for, not the intermediate landlord, his immediate landlord, but can subtenant sue the head landlord for lack of fitness? And I think in principle, that's a possibility as a positive covenant. But I'm not going to say any more about that. I'm just going to raise it and move swiftly on. Lastly, damages. That's another issue potentially to consider. I'm not going to say very much about that. As Katherine has said, there are really there's no indication at present as to what the right approach to damages for unfitness might be, as opposed to damages for disrepair in Section 11. I think it's really strongly likely or strongly suggestive that there's going to be a very similar approach. So you're probably going to be ending up considering, just as with for Section 11, where there's going to be a very substantial degree of overlap, what is the best way of assessing loss by reference to a reduction of rental value of the property. Just coming finally towards the end of the discussion, there's a fifth item I've just thrown in here, which is the common parts and the application of Section 9A to the common parts. Practitioners will know that, in fact, Section 11 did not originally apply to the common parts of a block where there are flats. It was an obligation in connection with the common parts was only introduced in 1989. And as Katherine has referred to, Section 8, which actually is also in the Act, that too did not apply to the common parts. Although today, obviously, the Section 11 does apply to the exterior of the building to some extent under Section 11.1, and that we now have, after 1989, a specific subsection, Section 11.1a, which does apply to the common parts, to the extent that the landlord has an interest in those common parts. Well, what's the position under Section 9a? And to start with, I understand that this actually was originally missed in the original draft of the Act. I haven't double checked that, but my understanding is that this was originally missed and was indeed added hastily at a subsequent point in time. And it's quite an interesting subsection 6, and it says, where a lease to which this section applies of a dwelling in England forms part only of a building, the implied covenant has effect as if reference to the dwelling in subsection 1 included a reference to any common parts of the building in which the lessor has an estate or interest. So what it appears to say is that the obligation that we've already looked at, Katherine has referred to, we've looked at in Section 9A1, which refers to a dwelling, should be read as including a reference to any common parts of the building. But that potentially is understandable. And I've written out Section 9A1A as reinterpreted, possibly with the way it should read. And it says, in a lease to which this section applies, etc., there is implied a covenant by the lessor that the common parts of the building in which the lessor has an estate or interest are fit for human habitation, etc. And I think the only thing that is slightly odd about that is that and this is perhaps a little bit pedantic, but it does slightly raise the question as whether this is an appropriate test for common parts of a building, because the way in which the obligation is phrased is in relation to fitness for habitation. Habitation means an area, tends as certainly a colloquial meaning. Habitation means the actual thing, actual unit of property that you're living in. But more particularly, the test itself is whether, in terms of unfitness, it's whether something is reasonably suitable for occupation. That is the test. Well, I'll just ask rhetorically, is it really the case that common parts ever are occupied by a tenant? Now, at the end of the day, one can have no doubt that probably the courts will work their way around that, and that they'll have a way of interpreting these provisions to mean that the common parts are reasonably suitable for the tenant in their occupation of the dwelling house. But it is a little oddity. Common parts, how could this unfitness obligation be raised in common parts? Fire safety in common parts we've already touched on. Another possibility is where you have a steep staircase in common parts. If there isn't a handrail there, formally that would not be caught, but it will be caught today. So, lastly, how much difference is this going to make in practice today? And the answer is that it's not making very much difference yet. It's probably going to be a year or two before we see this coming through, because there'll need to be unfitness for a significant period of time before there's a decent claim, before practitioners can get a claim going. So it's going to be a while yet, and it shouldn't be surprising, as Katherine and I scouring around haven't been able to find anything relatively new on this. Just a thought here. I did see an expert report relating to mold and dampness the other day, where the expert said it's not prejudicial to health, the circumstances of the flat, therefore it cannot possibly be unfit for human habitation. And I think that's certainly a fair conclusion. If as it stands, if something is not prejudicial to health, it's probably unlikely to be unfit. But note that prejudicial to health has potentially a narrow meaning under the Environmental Protection Act, and as we've discussed in relation to sound, mentioned in relation to sound insulation, there's no strict identity between the two. The unfitness for human habitation is broader and encompasses quite a lot, and it's worth looking at. It's worth looking at the list of items that potentially fall under the new obligation. So I think we are there now, and we are happy to take questions. And at this point in time, we will hand over to you.
We've been answering questions as we've been going along. I think there is just one question that we've not answered, which I could read out to you, Desmond, if you would be.
Yes, is it in the Q&A section?
It's not, it's in the chat section. So it's, would it be right to say that this act applies to all secure local authority tenancies, regardless of when the tenancies commenced? This is because such tenancies are periodic in nature. So I would just say on that if it is a periodic tenancy, then since the 20th of March of 2020, then yes, the Act does apply to it.
Yes, the only thing I totally agree. The only thing I'd add to that is that it is absolutely right in the main that local authorities tend to grant periodic tenancies. I can't remember ever seeing a fixed term tenancy granted by a local authority in my practice. Nevertheless, in theory, there are some circumstances in which fixed terms are granted. So just watch out for the transitional rules on that. There are one or two exceptions in section 9B. Yes, some fixed terms. There are fixed terms which do not appear to be caught. I think the question was, does it apply to all of them? It does apply to all of them. There are one or two where it does. I think it's non-secure fixed term tenancies granted before the 20th of March 2019, which are not renewed, avoid the Act up to their expiry date. So that's section 9B, subsection 3. So just have a look at that. Maybe if it's non-secure, probably it's not local authority tenancy. So that's, I think actually, at the moment, I can't think of anything. But just have a look at the section 9B, because it sets it out in detail. In the main, yes.
Does apply to non-secure temporary accommodation? I think you touched on that, Desmond, did you?
I did. I'm just trying to, I just lost my screen. Can you see me? Or
Yes, I can see you.
you can. I don't know what's happened to my screen. Right, yes. I'm just trying to, is that in our chat section?
This is back in the Q&A section.
This is back in the we are back in the Q&A. Sorry, I'm being very slow indeed.
No.
Right, where is that one?
So in
does it apply to temporary accommodation? Is the question, does it apply to temporary accommodation?
Yes.
Yeah.
To non-secure temporary accommodation.
Non-secure temporary accommodation. Yes, it does. Two points to make here. There are a lot of local authorities whose temporary in their agreements for temporary accommodation, they attempt to create a license agreement. And I don't prejudge the issue about whether those attempts have been successful or not. Everything will turn on the precise agreement and whether that creates a lease or a license. As Katherine said, if it creates a license, there is no Section 9A unfitness obligation implied into the terms of the license. If it creates a tenancy, then the Section 9A unfitness obligation will be implied into the tenancy. It doesn't matter whether the tenancy is technically secure or not. Common law tenancy will suffice.
There's a fairly long one. I think that's about damages. So
right, who's the name of the person who has? Is it Jensen?
Yes.
Right, I saw a converted office building that has been turned into residential apartments. The CLT client said that he took the AST and then discovered that the wall was only 3/4 finished on one of the dividing walls with the neighbouring apartments. Council said that the wall breached fire regulations. In the absence of psychological harm, risk fire, how do you think damages would be calculated under fitness for habitation? Well, this is a very good question, actually. It's an interesting question because when you have Section 11 claims, you could say that the assessment of damages in terms of the inconvenience and distress, because that's ultimately what you're assessing. What does the inconvenience and distress cause to the tenant? You could say that it can take a number of forms. You can say it's inconvenience because they have to mop up water. They could say it's inconvenience because they have to go down and wash their laundry down somewhere else. Or you could say there are various types of inconvenience, getting up in the middle of the night if some water's dripping on you. But then there are things like the electrical system not working very well, or concerns about safety and things like that. And these are all matters which are taken into account as part of the assessment of the damages claim. Now, it seems to me, and I know I'm being quite general about this, it seems to me that there is no question that concern about the fire protectivity or fire safety of the walls of a flat is something that the courts are going to take into account when they're assessing damages. If you say to me, well, what sort of reduction in rental value are you going to be given? Well, I think that's as long as a piece of string. Obviously, the expert will explain what sort of risk it is, and if the tenant is aware of that and concerned about it as a question of fact, well, that could be like concern about the electrical system and whether a fire would start as a result of a defective electrical system. Very, very similar indeed. So difficult to answer with any more specificity than that. Thank you very much for that question. Any more questions coming from the?
No, I can't see any in the chat.
Fabian has asked another question again, which is reflecting the non-secure temporary accommodation. I think actually that is also covered by the answer to Jenna's question. I don't know if you think, Katherine, there's anything else to add on that. it very much depends on whether it's a license or a tenancy. I think we covered that.
Yeah. I think the question about the drafting, whether terms should be included in the tenancy to sort of help with the not contracting out, but the applying, or what comes under the I think what you were talking about with the where if there's something that is in a breach of the tenant's covenants, then it won't fall under the obligation, and whether there's a way of then drafting the tenancy agreement to reflect that, so that there are more breaches of the tenant's obligations that sort of limit the landlord's duties, and whether those could then be drafted as an addendum or separate form to the tenancy, I think was the question.
I wouldn't. Yes. Oh, right. Well, thank you for that. Thanks, Katherine. I'm not picking that up. I think it's much more forceful when you're doing that to do it in the tenancy agreement. I mean, a tenancy agreement, although traditionally a short-term residential tenancy, well, traditionally a short-term residential tenancy agreement has loads of obligations on the tenant about cleaning, and that if you've social landlords, the tenant's handbook has lots of obligations. Why wouldn't you say to the tenant that the tenant has got to make sure that the right number of people are living there, they don't drive washing on the radiators, etc., etc., if you think there's really an issue? It seems to me to be, I mean, this is something that parties, landlord and tenants, fight over regularly, about whether the tenant's use of the property is causing or contributing to condensation, dampness, and or mold. Well, yes, you could argue. Well, if you can prove that, well, then that you get some sort of mitigation, and that's you don't really need to write it into a tenancy agreement. I think it's much better to write it into a tenancy agreement. The Act's specifically providing for it. It's very interesting. I mean, we're speaking here to both landlords and tenants advisors, but certainly in the past, and no, it's quite a regular thing that you see photographs of premises where you see mold on the walls. You see that. And the question that does arise in the mind is, well, why hasn't somebody rubbed that off? I mean, yes, it shows that this is a property that as suffering mold, but if you've got an expert, well, then the expert can deal with that. Why has the mold been left on the wall? It shouldn't be left on the wall. No tenant should ever, in a situation where they're suffering mold, the mold should never be left on the wall. And if in the circumstances where it's drawn to the tenant's attention that the mold should be rubbed down regularly, yes, that's inconvenient. Go back to the question about levels of inconvenience reflected in damages. It's very inconvenient to have to clean your own property and the walls and windows to get mold off, but equally it means that you're not living in a property which is prejudicial to health, which is far more serious. So yes, I would put that all in the contract. And it's interesting because if you look through the 29 prescribed hazards that Katherine referred to, which are incorporated into the obligation as you consider it, whether it's reasonably suitable for occupation, probably damp and mold is actually really the only one, or one of the few ones, where the tenant can actually make a positive contribution to try and make the property fit. Most of the other items that are referred to and that are contemplated are really items that the tenant can do very little about. And I think I haven't considered it in detail, but there's probably less that the tenant can do. But hey, damp and mold growth is one of the key ones that's a new issue under this unfitness. And the tenant can do something about it. And you can make the tenant promise to do so in the terms of tenancy. Nothing objectionable with that.
I think that is all the questions that we've had so far. A few people have.
Geraldine's asking about the answer to Gina's question.
I will just, I've just copy and pasted that for Geraldine.
Okay, brilliant.
And then see that. But otherwise, there are, yes, a few questions about getting the PowerPoint slides and seeing the video. It will be eventually uploaded to the 42 Bedford Row YouTube channel, so you'll be able to access it there. And of course, the slides play as it goes. If you did want the slides sent directly to you, I think that is something that you could probably email the clerks about, so that they could send those over.
Absolutely. Well, thank you very much, everyone, for listening in. And this will actually go onto our dedicated 42 Bedford Row YouTube site, so you'll be able to catch it. If you've missed one of those slides, there's something on it. I'm hoping it will be shared soon, so you should be able to get access to it there. Thank you, and have a pleasant evening.
Thank you, everyone.